It's a very common practice in India that you get a call from the police station that Mr. X has filed a police complaint against you, or Mr. Y has filed a police complaint against you, or a notice has been issued from a criminal court asking you to appear. The first thing that anybody would do is to react in a negative manner and feel really scared as to what will happen if he or she goes to the police station or if he or she approaches the court. Now, I would like to advise all viewers that there is nothing to panic. In India, it is extremely easy for people to make false criminal cases against anyone. Sadly, while it is easy to make a false case against any person, it is not very easy to prove or take it to its logical end. So there is really nothing for you to worry. Go to the police station, find out what are the details and why you were summoned, see what is your role, answer them correctly as and when it's required, and bring a copy of the complaint so that you can take it to a lawyer and take up the matter as it should be done by a legal person. Now, what happens when you get a notice from a court? The same thing. Don't panic. Go to court, appear directly or appear through a lawyer, get a copy of the case that has been filed against you, and then approach a legal person in order to understand what your rights are. So now the real question is, what is it that you can do and can you fight back? Can a person who has filed a complaint against you falsely be punished? Now let us be honest. In today's time, law is not only used for justice, but it is being used regularly as a weapon for harassment, pressure, or even revenge. In this video, I'll explain to you what exactly is a false case in law, the difference between a false case and a weak case, the step-by-step remedies that are available to you, and most importantly, what the Supreme Court of India has said on this. Now, let us understand the first thing. What is a false case? To understand what is a false case, we have to distinguish it from a weak case. Every case that fails in a court is not a false case. It could also be a weak case. But a false case is a case where allegations made are knowingly false with the intent to cause you harm. And in legal terminology, this is known as malicious prosecution. Whereas a weak case is a case that fails in court because you do not have enough evidence. Now, let us see what the Supreme Court of India has said about maliciousness. In West Bengal State Electricity Board versus Dilip Kumar Roy, a 2007 judgment, the Supreme Court clarified that malice or malicious in law means a wrongful act done intentionally without just cause or excuse and not merely personal ill will. It was held that to prove malicious prosecution, a person must show absence of reasonable cause, existence of malice, and that the proceedings ended in his favor. Hence, the burden of proof will be lying on the person who has been prosecuted. Most importantly, the court emphasized that mere acquittal does not make a case false. If the complainant acted on an honest and reasonable belief, no liability will arise. Applying these principles, the court set aside damages awarded, holding that allegations of malicious prosecution must be proved with very clear and cogent evidence. So legally, you must prove that no reasonable cause is there as far as you are concerned, that there was a malicious intention of the person who wanted to frame you in a criminal complaint or a criminal case, and that the case has ended in your favor. Now let us go to the second part, misuse of law, the ground reality. Like I said earlier, false cases are very easy to file in India. They arise mostly in matrimonial matters, 498A, or the domestic violence cases, property disputes, business rivalry, and sometimes even personal vendetta or revenge. There is a landmark case of the Supreme Court called State of Haryana versus Bhajan Lal, a 1992 case where the court has laid down certain guidelines for quashing FIRs, holding that high courts can intervene when allegations do not disclose any offence, are absurd or unsupported with evidence, or where proceedings are initiated maliciously for harassment or for personal revenge, which includes civil as well as criminal cases. The court cautioned that such powers must be exercised sparingly when quashing an FIR, but the court must see whether the FIR is an abuse of law and whether or not it is genuine. Why does this matter? This matters because anyone can file an FIR, the police machinery can get activated, and obviously your life will get disrupted once there is a criminal case pending against you. Now let us see the step-by-step remedies. The first in any criminal matter is that your goal should be to get a discharge. That is, you ask the court or the police to discharge you because there is nothing in the complaint against you. The second, of course, if there is something in the FIR that makes you liable for a trial, then in that case you would seek acquittal. And in many cases we advise that an FIR should be quashed. That is, if you feel after reading the FIR and the charge sheet that there is no proper averments made against the accused person, that is your client, you can move for FIR quashing. Now let us understand what is quashing. If a case is false on its face, then you can approach the High Court under 482 CRPC, which is now 528 BNSS. In Pepsi Foods versus Special Judicial Magistrate, a 1998 Supreme Court case, the Supreme Court clearly held that summoning a person in a criminal matter is a very serious matter and cannot be taken casually. The court emphasized that criminal law should not be used as a tool of harassment, and high courts have the power to intervene and quash such proceedings if they are deemed to be abuse of the process of law. Now, what are the practical aspects? Practical aspects are you need to get a good lawyer. You have to see that your lawyer drafts a good quashing petition, which will show that there is no prima facie case against you and will also demonstrate malafidis of the person who has made a complaint against you. Now, this was the criminal law. Now, let us look at the civil law. What are your options in civil law? In civil law, you have what is known as civil damages. In this case, you can sue the person who made a false complaint against you for malicious prosecution, and the person will have to pay damages. This, of course, would only be if you have been able to get the FIR quashed or if you have been acquitted. Now, coming back to that case we had discussed earlier, State of West Bengal Electricity Board versus Dilip Kumar Ray, Supreme Court confirmed that if prosecution was malicious, compensation can be claimed. Now, what is it that you can recover when you are asking for compensation? First, the legal costs of going to court, defending yourself, and then finally filing another case. Second, the mental trauma. Third, damages for loss of reputation. And if you are in business, then loss of business. If you have lost your employment, then loss of employment. But however, there is a reality check that everybody must be aware of. Indian litigations are very, very slow. So it is time consuming, evidence takes very long, but it has to be pursued carefully, otherwise matters don't end. Now, criminal action can also be taken against a false complaint. And in such a case, you can file a case under Section 217 of BNSS, which deals with giving false information to a public servant, that is the police, or 248, which punishes false criminal charges made with the intent to cause harm, or 229, which is giving false evidence. So filing a false case is not only just a wrong, it's a criminal offence. Now let us see what the Supreme Court has said in a very important judgment, Chandra Babu versus State, 2015. The court has held that the scope of further investigation and the powers of the court is in supervising criminal proceedings. The court emphasized that the power to direct further investigation must be exercised cautiously and only to achieve the ends of justice, ensuring that investigation remains fair, transparent and proper. Another remedy that you have both in civil as well as criminal law is filing for defamation. False cases generally destroy your reputation. So you can move a case for defamation in criminal law where there is a punishment, or you can move for defamation in civil law where there is compensation. Now, in a landmark judgment called Subramaniam Swamy versus Union of India, 2016, the Supreme Court held that the right to reputation is a very integral part of our right to life that has been assured under Article 21 of the Constitution of India, the court observed that reputation is a facet of human dignity and cannot be allowed to be tarnished without justification. Now let us examine another aspect. If police misuses the power, what should you do? The first answer is you can approach the High Court. The principle extends even when there is illegal arrest or when fabricated cases or abuse of state power. Now, let me give you some practical tips. If you are falsely accused, never panic, never try to get into an illegal settlement or ignore summons. Always try and find the evidence or preserve the evidence if you have it. Keep your documents ready and approach the court as early as you can. So the golden insight is not every failed case is a false case. Courts are very clear. If there is a reasonable cause, even if the case fails, it is not necessary that it is malicious prosecution. Hence, with this, I would like to conclude that you as an Indian citizen have a right to defend, you have a right to compensation, and you have a right to prosecute the wrongdoer in criminal law, both for damages as well as for other things. So if someone misuses the law against you, remember the law gives you a right and the power to restore your dignity. If you have found this useful, please like the video and please share the video so that we are able to reach a better audience. Thank you, and till we meet again, Namaste.